My apologies on behalf of the court for the delay, but I just want to assure everyone that because these matters are serious, the rulings on exhibits, the rulings on testimony, and exhibits generally have been taken very seriously by this court. We have tried very hard not to make rulings in haste, and again, that is what we have been doing now. We have reviewed your offers, and the court makes the following as its rulings. Exhibit number C-152 will be received with the court determining the weight that will be given that exhibit. As to exhibits C 1100 through 1158, consistent with contestants' representations at the time the exhibit was offered, the court will receive into evidence C 1100 through C 1155 to include only the voter registration application and the absentee ballot return envelope. As to C 1156, C 1157, C 1158, those exhibits will not be received as they are untimely. I believe those are all of the unfinished matters. Mr. Lillehag?
Your Honor, with respect to C 1100 to 1155, may I add a foundation objection to that as well?
You may. Thank you. Overruled. They're received. With that, are we prepared for final arguments?
Yes, sir.
Mr. Hamilton, you may begin.
Thank you, Your Honor. Before I begin, I'd like to take just a moment to thank the court and staff for the courtesy and patience that you've shown to all of us during the course of this long trial. We collectively have nearly buried the court in paper and notebooks, filed innumerable motions, many on short notice, and generally imposed burdens on this court and its staff that perhaps can only be truly appreciated by the counsel sitting at the two tables before you. It's been an honor to appear before you, and on behalf of the Franken litigation team, I thank you for the opportunity. This court was convened over 2 months ago for the purpose of hearing an election contest filed by the contestants to challenge the certificate issued by the Secretary of State declaring and formally certifying that Al Franken received the highest number of votes in the United States Senate election held on November 4, 2008. Over the course of the last 7 weeks, contestants have called a variety of witnesses and election officials, offered copies of absentee ballot envelopes and absentee ballot applications, and advanced arguments to challenge that certificate. They've argued that some votes should have been counted but weren't. They've argued that some votes were counted but shouldn't have been. And perhaps most audaciously, they've argued that the entire electoral system in the state of Minnesota is broken and unreliable, and that the state's electoral database is, in their words, garbage and corrupt. To put it charitably, contestants' advocacy has rather dramatically outrun their evidence. Minnesota's electoral system is, as the evidence presented over the course of this trial has shown, a model for the nation. Minnesota was among the first states to create a statewide electronic database, which served as a model for the requirement in the Help America Vote Act that every state create and maintain such a system. It has detailed, consistent, and uniform standards for evaluating absentee ballots. It has robust anti-fraud protections built into the fabric of the statute governing elections in this state. Minnesota's auditors and election officials, many of whom testified in this courtroom, devote an enormous amount of time, energy, and expertise to ensuring that elections in this state run smoothly, accurately, and lawfully. Minnesota has one of the highest rates of voter turnout in the entire nation, and for good reason. Minnesota's electoral system works, and it works well. And of course, elections in Minnesota depend upon the efforts of thousands of citizen volunteers who staff polling places throughout the state, working from very early in the morning to long after dark in the evening. In 7 weeks of trial, the evidence has demonstrated that there were a small number of errors in this election. One of the voters, called by the contestants, for example, testified that she signed the roster page but voted an absentee ballot. Gail Kecker so testified on February 3rd. Election officials have testified to errors in sending the wrong materials to a registered voter, or overlooking hyphenated names in a poll book, or misplacing relatively small numbers of ballots after Election Day. As I said in opening statement, no election is perfect. No election has ever been perfect. No election ever will be perfect. That's the way our democracy works. It relies on citizens. It relies on volunteers. It enforces rules against fraud, and it recognizes that any human institution is, and always will be, imperfect. But the record simply could not be clearer that this election was no different than the many elections that this state has conducted throughout its history. It was fairly administered, carefully run, and featured a large voter turnout. The meticulous hand recount involved thousands of citizens, elections officials, and campaign volunteers recounting by hand 2.9 million ballots. In the course of this trial, we've developed a much better sense of just how monumental, time-consuming, and commendable a task that was. The result of that recount, the certificate signed by the canvassing board, was accurate, complete, and definitive. So to those who would challenge the way we run our elections and challenge the Minnesota electoral system that has for years stood as an example of one of the best run systems in the nation, to disappointed candidates who would seek to tear down the system in an attempt to overturn results they wish were different, I say to them, prove it. Indeed, that's precisely why Minnesota law, like the law of virtually every other state in the union, requires contestant seeking to challenge the certificate of election to demonstrate not just that mere error has occurred, but that if error occurred, it made a difference in the outcome of the election. And that is exactly what's missing from the record before this court. In all these binders piled up all over this courtroom, and all the testimony from that witness stand over the long 7 weeks, after all that, contestants stand bereft before the court with virtually no evidence to support any of their claims, no evidence to support the incendiary accusations and allegations leveled against Minnesota and its electoral system, and no evidence to overturn the certificate issued by the state canvassing board. As I mentioned at the outset 7 weeks ago, overturning the results of the recount, the hard work of the local and state canvassing boards, and the state canvassing board's certification of the results would be a breathtaking exercise of judicial power. It should be undertaken only in the rarest of cases and only on the most powerful evidentiary records. Nothing close to that has been presented in this courtroom. Contestants have dropped most of their claims, and to those remaining, they have woefully failed to carry their burden of proof. And I'd submit that their claims must be dismissed. Now, as the court is aware, this trial commenced on January 26, 7 weeks ago, 35 court days. In that time, the court has heard from 134 witnesses and reviewed 2,182 individual exhibits, excluding those just admitted this morning, comprising thousands of pages and compiled in hundreds of binders scattered throughout this courtroom. 69 voters have appeared and testified in defense of their ballots. 38 counties and cities have appeared, some after driving long hours through snowstorms that shut down interstate highways with drifting snow. Since the trial began, a new federal government has formed. Congress is convened, and even winter seems to be loosening its grip. We'll be submitting a final set of proposed findings of fact and conclusions of law, and in some considerable detail, reviewing all of the evidence and all of the applicable law. But I'd like to take a moment to review at least some of the more fundamental principles that govern this election contest. First, as this court has repeatedly noted, there is a strong presumption of regularity that attaches to every election. Minnesota Court of Appeals said in the Kieran versus Roach case in 1986, quote, "The certificate of the proper canvassing board declaring the result of an election is prima facie evidence of the result and places on the contestants the burden of showing that the person elected did not receive a majority of the legal votes." And there's a good reason for that legal principle. Election officials charged with administering elections are presumed to act in good faith and to do what the law requires of them. As a result, in an election contest, contestants have the burden of showing that an election is invalid and that if errors occurred, they were sufficiently serious to change the outcome of the election. The law requires proof that an error did in fact change the outcome, and that's a heavy and demanding burden. Now, there appear to be three primary claims advanced by petitioners remaining for decision by this court. First, the claim that a number of absentee ballots were improperly rejected and should be counted. Second, the claim that there was double counting of duplicate ballots in several precincts in Minneapolis. And third, the claim that the state canvassing board committed error in determining that 132 ballots in Minneapolis, Ward 3, Precinct 1, were missing and reverted to the machine tapes as the best evidence of the vote totals from that precinct. I'd like to address each of the contestants' claims in turn. First, of course, is the absentee ballot claim, and that is the contestant's central claim before this court at this point. The contestants contend that there were improperly rejected absentee ballots on Election Day or during the recount following the Supreme Court's December 18 order. Contestants claim that the opening of such ballots during the recount but changed course once Senator Coleman fell behind, and then began arguing there were ballots that should have been opened but were not. Contestants began this trial with a universe of about 4,800 ballots. In its February 13 order, this court made it clear that in order to prevail on having those ballots opened and counted, the contestants, and indeed the contestees, would need to show that the ballots were legally cast and not simply wrongfully rejected. As the court emphasized in an order 10 days later, February 23rd, quote, "The court cannot order these ballots opened and counted until it is satisfied, based on the evidence, that such ballots have been legally cast." And the court made it clear in those orders precisely what Minnesota law requires for an absentee ballot to be lawfully cast. This is no secret, and it hardly was a new set of rules. Counsel for contestants, in fact, had identified most of these rules as far back as December 2008. Mr. Trumbull's email recites in a letter complaining that no absentee ballot should be opened many of the very rules identified by this court in its order. This court made what was clear in Minnesota law even more plain and obvious. It explained that to demonstrate that a ballot was legally cast, contestants must prove a number of facts through competent evidence, through documents admitted, through evidence from the witness stand. First, they must show that each ballot that they wish to have counted was submitted by a registered voter. To be valid, a registration application must contain all of the information required by the statute. It must also have been received by October 14, 2008, or submitted as part of a same-day registration application. As the court noted, even if a voter's failure to register was a result of official errors or omissions, his or her vote cannot count unless the voter was registered. If a voter moves, even within the same precinct, he or she must re-register. In addition, contestants must demonstrate that a voter complied with all the statutory requirements for an absentee voting. And the court has, in its orders, made those clear, and through the course of examining witnesses, we've emphasized those elements. That the voter has completed an absentee ballot application, that the names and addresses provided on the return envelope for the absentee ballot match the name and address provided on the absentee ballot application, that the application contained the voter's genuine signature, that the absentee ballot was submitted in a return envelope signed by the voter in the certification box, unless there was evidence that it was hand-delivered to the counter and the local election officials didn't provide the voter an opportunity to correct the certification. This court has noted that the signature on the return envelope must match the signature of the individual who made the application for the ballot. The absentee ballot must be witnessed by a registered voter or a notary public or some other individual authorized to administer the oath. Witness must have provided a name, address, and signature. Proof of residence must be shown and provided on the envelope. The absentee ballot, if witnessed by a notary, the notary must have provided the stamp. If the absentee ballot was submitted by a voter, the voter must have been registered in that particular precinct and at that address. The absentee ballot must have been timely received and properly delivered. The voter must only have voted once. Now, those rules I didn't just make up, nor did this court. They are clear, they are found in Minnesota law, and it's settled Minnesota law and has been for years. Given these mandatory requirements, the question whether an absentee ballot was lawfully cast and improperly rejected must be determined on a case-by-case basis and on an individualized evaluation, precisely as this court has done for the number of ballots it has reviewed over the course of Mr. Nouwen's summary judgment motions. Contestants, in response to the court's orders in February, withdrew over 1,000 ballots, leaving just 3,687 at issue. As this trial has unfolded, contestants have utterly failed to prove up even those ballots. They've failed to offer specific admissible evidence to establish the necessary elements required by state law and highlighted by this court in its series of rulings since the trial has begun. Many of the voters included by contestants are simply and clearly insufficient, even the small handful who appeared in person. Peter DeMuth, for example, failed to sign his absentee ballot application, instead used a computer mouse. Under settled state law, that's simply not sufficient. We provided the court in support of our motion to dismiss with a series of spreadsheets analyzing the evidence presented during the course of this trial in specific detail to assist the court in its task that lies before it. Contestants, in turn, provided their own spreadsheet just 2 days ago on Wednesday morning, analyzing the same evidence. And I'd like to take a moment to take a close look at that spreadsheet, because it alone, contestants' own spreadsheet, demonstrates the almost complete failure of proof. It is an admission of how little they have proven over the course of this trial. I'd like to look first at the legend for contestants table. It's important in reviewing the table provided by contestants on Wednesday to look at the definitions, because they're not obvious and in fact often mean precisely the opposite what one might assume they mean. For example, in each place in the table provided by contestants where they provide the abbreviation witness reg or wit reg, it actually means that the witness is not registered. Wit reg means non-registered witness, and then they have the argument that it should be counted in view of testimony. But what it means is a non-registered witness. FPCA, every place you see FPCA on contestant schedule, curiously it means contestants admit that there isn't a federal postcard application in the record. Voter for whom a federal postcard application could not be found. So FPCA, oddly, means they don't have an application. SVRS. Notice that according to the key, anywhere the notation SVRS appears, it means there is no record evidence to support the fact of registration for either the voter or the witness or both. SVRS means there is no evidence in the record. The notation D means that the voter registration application was found by the county and the Secretary of State to be deficient. NA means there was no absentee ballot application. This is perhaps the most important single document in reviewing the absentee ballot claim presented by the contestees. So now let's take a look at contestees' spreadsheet, and I'll just look at a couple of them because I want to make sure that to review the contestants' version, the contestants' understanding of their own evidence. All right, this is one page out of a multi-page spreadsheet introduced and offered by contestants on Wednesday. The spreadsheet's large. There's a left-hand column that you can't see that identifies the county. The columns B and C identify the names of the voter, and then the evidence is summarized here. You can see column D provides a number, and that's an exhibit number, identified by the contestants for every voter for which there's an envelope. As you can see, envelopes are missing for the majority of the voters identified, the absentee ballots identified by contestants. This, again, is not our spreadsheet. This is contestant spreadsheet. The application, column E, again, in most instances, there's no absentee ballot application. Column F is proof that there was no, that the voter didn't otherwise vote. That typically comes from the certifications provided by the counties. As you can see, there's very few boxes are checked there. Voter registration, it's a complete default. In every instance on this page, there's a notation SVRS appears, and of course, as the key demonstrates, that means there is no evidence that the voter is registered. Witness registered in all but 4 instances on this page. There's no evidence that the witness was registered. In 4, they provided the exhibit number, exhibit 616. So let's take a look at another page. So here's another page, again from contestants' spreadsheet. Again, it's set up the same way. Here there's more envelopes, but almost no absentee ballot applications. Nothing to compare the signatures, nothing to confirm whether address and signature are the same. On this page, there's a complete default with respect to any evidence that these voters didn't otherwise vote. Simply nothing in the record. Under voter registration, there's maybe 10 or 12 where there's a specific exhibit cited, and the rest, again, a default. And an utter default with respect to the registration of the witness. There's simply no evidence provided for any of these. I'd submit that this is the starting place for the analysis. The universe, in fact, is much smaller. Let's go on to the next one. Another page, again, some evidence. In most cases, they've been able to identify an envelope. In only 3 instances have they been able to provide the court with an absentee ballot application. In no instance have they been able to prove the voter didn't otherwise vote. In no instance, not one on the page, have they proved the witness was registered. And in almost all cases, they've failed to prove that the voter was registered. In a large number, in every one of these, there's a failure of one or more essential elements identified by this court. By contestants' own reckoning, they've failed to prove that the ballots were lawfully cast and improperly rejected. In many cases, contestants have failed to offer admissible evidence that the voters completed absentee ballot applications, or if they did, that the signatures and address matched the address and signature on the absentee ballot envelope. Or they failed to show that the absentee ballot envelope was signed, or that the ballot envelope is even in the record, or that the voter was registered, or that the witness was registered, or an individual authorized to administer the vote, or that the voter didn't otherwise vote. It's just a failure of proof almost completely with respect to those elements. And I did want to point out in passing that something's happened here during the course of the trial. There were originally in the universe of 3,600 a very large number of signature mismatch ballots. Over the course of the trial, contestants withdrew hundreds of those signature mismatches in a concession that, in fact, they weren't even close. At the last moment, to inflate the number back up, those signature mismatch ballots have all been added back in. I don't contest their right to do that and to ask this court to review it, but only point out that it deserves the signature mismatch ballots may not be specifically called out in the spreadsheets, but every signature mismatch ballot should be closely examined by the court because there are several hundred in there that contestants at one point in this trial even admitted didn't really match. The failure of proof is simply breathtaking. If you sort through their spreadsheet, which we've done in a rebuttal spreadsheet filed yesterday using their data just simply to help the court analyze it, there are a grand total of 6 ballots as to which there is competent evidence before the court meeting all the requirements to show the ballots were lawfully cast. That's it. 6 ballots as to which, using their data and their spreadsheet, where they offered a complete set of proof. It's breathtaking. But it's not surprising. In fact, as the record has demonstrated, Minnesota's system for reviewing and evaluating absentee ballots works, and it works well. It relies on the consistent, uniform standards applicable throughout the state. It relies on consistent statewide training offered by the Secretary of State and every auditor's office across the state. It relies on the hardworking citizen volunteers who staff precincts across the state. So it just isn't surprising that contestants were able to demonstrate only so few absentee ballots that were both lawfully cast but yet improperly rejected. There simply were not that many to be found. Indeed, as the evidence has shown over the course of the trial, the ballots have been repeatedly reviewed by local election officials. First, when they were received, during the original canvassing board process, during the recount, again during the Supreme Court review process, and during the final canvassing board meetings at the end of the recount. All of those election officials applied the simple, clear, and mandatory requirements of Minnesota law applicable to absentee voting. The law presumes that those officials acted in good faith and did what the law required of them. And the testimony in this courtroom has demonstrated that the vast majority of the ballots were rejected because, under settled Minnesota law, they should have been rejected. So at the end of the day, contestants' absentee ballot claim, after all this paper, after all this evidence, fails. Contestants' second claim concerns original and duplicate ballots. Contestants refer to it as their double counting claim, but that's really a misnomer. There's been simply no competent evidence at all of double counting. Instead, contestants' duplicate ballot claim consists of a mass of precinct-level data, suggestions of minor paperwork errors or inconsistencies, and insistence by counsel that this court should, on that basis alone, conclude that ballots were double counted. With respect to only a single precinct did contestants present anything else, and for that single precinct they presented nothing more than unreliable hearsay. The evidence falls woefully short of proving that claim. And the history of the claim as it progressed through this process makes its weakness clear. In the notice of contest, contestants alleged double counting in dozens of precincts. By the end of their case, the claim had shrunk to 10, not coincidentally 10 precincts in Minneapolis, which Al Franken won by a large margin. And for each of those precincts, contestants might have tried to present evidence in the form of competent testimony to analyze the ballots and help the court determine what might have happened on election day in those precincts. But they didn't even try. Instead, they introduced a jumble of paperwork, rosters, machine tapes, challenge ballots. Without explanation, those materials prove nothing. Apparent discrepancies might have been due to any number of reasons. Could be due to errors in voters signing in or failing to sign in at polling places, differences in the way judges mark rosters, accidental misplacement of ballots, failures to create duplicate ballots, or simple math errors in addition. Without testimony from the election officials who were there, the citizen volunteers who staffed those polling places, who were dealing with those original source documents, we just don't know. What we do know is that if every ballot tells a story, every roster tells 100 of them. These exhibits, without more, do not prove double counting. They don't even come close. The one witness contestants did offer to the court was Pamela Howell. Ms. Howell, a longtime Republican activist, apparently was eager to testify, so eager that she called all 3 Coleman lawyers and volunteered her testimony. Even while she refused to speak with the Franken lawyers, she listened to the advice given to her by Coleman's counsel how to best avoid pinning down her testimony and to avoid disclosing it. But the court need not discount Ms. Howell's testimony solely on the basis of bias. Even on its own terms, the testimony was unreliable and unpersuasive. Ms. Howell provided hearsay from late on election night after 15 hours of work. What she supposedly heard was vague and indefinite. What did the judge mean when allegedly she made the out-of-court statement, quote, "the ballots weren't labeled," close quote? How many weren't labeled? What steps did she take to find out? Why didn't she prepare an incident report? If she did, why wasn't it introduced? And there's more. The facts in the record actually refute Ms. Howell's testimony. Contestants introduced 14 challenge ballots. Ms. Howell, on the stand, under oath, testified that the judges at the table next to her initialed the ballots. But if you look at the ballots, they're in evidence. Not one of those ballots is initialed. In short, if there was a problem in Precinct 12-8, it hasn't been proven. The evidence just isn't there. When you put Pam Howell aside, the only thing you have for those Minneapolis precincts are differences between the number of names on the roster and the number of ballots. Those kinds of discrepancies occur in every election. Election judges aren't perfect, particularly in a busy presidential year. Election judges work long hours under heavy pressure long into the night. Errors in precinct-level paperwork hardly proves that ballots were double counted. It doesn't even suggest it. Indeed, if double counting actually occurred, then where is the actual evidence? Where is the witness who failed to mark the ballots? Where was the election judge who said, "Oh, we forgot to mark the ballots"? The failure to produce actual, relevant evidence from witnesses with firsthand knowledge from that witness stand is far more telling than the hodgepodge of paper and secondhand hearsay that actually was produced in this courtroom. And of course, there are better and far more plausible explanations for what happened. Lost duplicates, as happened in Minneapolis Precinct 8-7, or original ballots that never got duplicated, as also happened in 8-7. And absentee or UOCAVA ballots that arrived late are opened by tired election judges but set aside and neither initialed nor counted nor marked on the roster. That's a far more plausible explanation for what happened in Pam Howell's precinct. There are a number of open absentee ballots that don't appear at all on the rosters. But even if contestants had presented evidence they couldn't prevail on their duplicate ballot claim, the law is simply against them. The recount was of original ballots, which is entirely consistent with the law in Minnesota. As the Minnesota Supreme Court said in late December, quote, "There can be no dispute that unmatched original damaged ballots are valid ballots and the votes marked on those ballots should be counted in the election," close quote. In addition, of course, the parties agreed And that agreement was ratified by the state canvassing board in the recount procedures, that original ballots should be counted where there are differing numbers of originals and duplicates. Contestants' attempt to back out of their agreement, both here and before the state canvassing board, is as cynical as it is groundless. It's undisputed that contestants agreed to the rule, Rule 9. It was an important part of training their own recount representatives. And when the issue of discrepancies arose between the number of original ballots and duplicate ballots on the very first day of the recount, they insisted in no uncertain terms that Rule 9 be enforced. And they asked the Secretary of State for clarification of the rule, and when they received it, they thanked the Secretary of State's office and said the clarification was, quote, perfectly clear. Only when the large number of original ballots in Wright County were recounted and the recount ended, and they determined that Rule 9 had not benefited them as they hoped, did they change their tune. And now they stand before this court and declare it was all simply a mistake. Rule 9 had the imprimatur of both candidates, the Secretary of State, the Attorney General, and the State Canvassing Board. Contestants are estopped from backing out of it. They have waived any claim. Contestants' duplicate ballot claim is simply wrong as a matter of law, and they've shown nothing at all that begins to establish double counting. Contestants' final claim is a claim challenging the certified results in the recount totals in Minneapolis, Ward 3, Precinct 1. As your honors know, the essential facts underlying the claim here are simply undisputed. The court's already ruled on the law. There's nothing left for this court. After Election Day, 132 ballots went missing in Minneapolis, Ward 3, Precinct 1. You heard Minneapolis Elections Director Cindy Reichert explain what happened. A few days before the conclusion of the recount, a member of Ms. Reichert's staff voiced concern over the collection of ballots that apparently could not be found. On Election Day, the officials in that precinct had placed them in the ballots in 5 Tyvek envelopes. They were labeled 1 of 5, 2 of 5, 3 of 5, all the way to 5 of 5. Several weeks later, however, during the recount, no one could find the first one, labeled 1 of 5. So officials counted the ballots for Minneapolis 3-1 and compared that to the total tally on the machine tape, and it confirmed the problem. 132 ballots had gone missing. So Ms. Reichert conducted an extensive investigation. She checked the incident log, she pulled check-in sheets, she determined how many people were in the precinct, and she confirmed that, in fact, there were 132 ballots that existed and went missing. So a search began, and it too was extensive. Officials and volunteers, trailing hordes of media behind them, checked the polling place, the storage warehouse, transport van, city hall, everything and everywhere they might have been. You remember Deputy Secretary of State Jim Geldman testified to his own participation in that extensive search. And indeed, Mr. Friedberg stipulated at this podium in open court that an envelope was missing and that, quote, everything humanly possible, close quote, had been done, that every conceivable place had been searched, and that nonetheless the ballots couldn't be found. Ms. Reichert presented this testimony, this information, to the state canvassing board, and representatives from both political campaigns had an opportunity to be heard on that question. Both sides submitted briefs. The state canvassing board considered the testimony, the parties' positions, and the briefing submitted to it, and determined that 132 ballots, in fact, had been cast and counted on Election Day and then gone missing. After seeking advice from Minnesota's Attorney General, the state canvassing board concluded that the proper way to account for the missing ballots was to use the Minneapolis 3-1 Election Day totals from the machine tapes. The board's conclusion on that point is entitled to deference in this proceeding. And for the most part, the facts underlying this are simply undisputed. The only argument half-heartedly advanced by contestants is to question the number of ballots at issue. But there's really no genuine dispute here. Contestants have introduced no evidence calling into question the number provided by Ms. Reichert after her extensive investigation. In any event, contestants concede that the ballots existed and are missing, and that's the relevant point. On February 23rd, this court's order addressed the governing law on this claim, and in so doing recognized the applicability of Moon v. Harris. Under that precedent, when missing ballots can't be found, election officials must turn to the next best evidence. Here, that is, as the canvassing board concluded, the totals provided by election officials on election day as a result of the machine tapes. We've heard extensive evidence from election officials. Not one of them suggested that the machine tapes are unreliable or anything less than an extraordinarily precise tabulation of votes cast. And for that reason, the canvassing board embraced those machine tape totals. Now, in this court's February 23rd order, the court noted that contestants had submitted an affidavit suggesting that the ballots might not actually be missing, and as a result, the ballots might be available as evidence, and left open that issue for trial. Since February 23rd, through the close of evidence in this case, contestants have provided no evidence going on to that issue, and certainly no evidence to prove the existence of those ballots or the numbers. To the contrary, contestants in their March 6 oppositions again stipulated to the relevant facts. There were 132 ballots that once existed that don't anymore, and so the issue before the court is now purely a legal one. But the law on this point is clear. It was proper for the canvassing board to count the election day totals. The law demands the same, and contestants' claim simply has no merit. Now, I'd like to spend a few minutes talking about contestees' two counterclaims advanced here. We frankly don't have a lot to challenge. A few isolated errors for an election in which Minnesota's election officials and citizen volunteers, in the vast majority of cases, accurately processed, recorded, and secured the nearly 3 million votes cast. There are two claims that we've advanced. First, we've asserted a claim arising over ballots that have gone missing from a number of other precincts around the state. Second, we've identified a number of absentee ballots that were lawfully cast but improperly rejected around the state, and I'll take those two claims in turn. First, we've asserted a counterclaim involving missing ballots. Just as the 132 missing ballots in Minneapolis 3-1 required resort to election day totals, the missing ballots in 13 other precincts require the same treatment. For each of those 13 precincts, we presented considerable, competent, and essentially unrefuted evidence of missing ballots. I prepared a summary table on this claim. First, you heard testimony yesterday from the Oakport Township in Clay County. 5 ballots went missing on election night from election night to the recount, even though Norm Coleman won that precinct handily. All 5 of the missing ballots were for Al Franken. We proved a net 10 votes in Dakota County. Inner Grove Heights 4 lost 24 ballots, a net loss to Al Franken of 4 votes. Rosemont 4 lost 9 ballots, with a net loss to Al Franken of 6. In Hennepin County, we proved 16 missing ballots from 3 precincts: Minneapolis 3-3, Plymouth 3-18, and Richfield 1-14. All told, Al Franken lost 8 votes. There were 8 missing ballots in Olmsted County. Rochester 3-6, net loss to Al Franken, 2. In St. Paul, 18 ballots missing for a net loss to Al Franken of 11 votes. 5 missing ballots in St. Cloud with a net loss of 2. And finally, there were 28 missing ballots in Washington County. Though Norm Coleman won Washington County by a 9% margin, Al Franken suffered the most from the missing ballots for a net loss of 14 votes. Most of these instances, diligent searches were conducted, and the missing ballots could not be found. In these precincts, there's no evidence of machine jams. In fact, in each instance, the auditor testified that the machine and the machine totals were accurate. The best evidence in those precincts is the machine tapes. Based on that evidence, unrefuted by contestants during the course of this trial, Al Franken's vote total should be adjusted and increased by 52 votes. Now, our second and primary counterclaim is contained in Exhibits X and Y to our amended answer. In those two tables, we've identified a large number of absentee ballots cast around the state that were lawfully cast but wrongfully rejected by election officials. Of course, the same standards apply to our counterclaims as to contestants' absentee ballot claims, and I, of course, won't repeat them all. But this court has carefully and specifically noted the requirements of Minnesota law with respect to lawfully casting an absentee ballot, and those standards apply no less to the ballots we have identified. The voter has to sign the absentee ballot, the signature has to match the absentee ballot application, the addresses have to match, the voter and witness has to be registered. All of the other requirements imposed by Minnesota law must be established by specific admissible evidence in the record. We've presented evidence with respect to hundreds of individual voters identified in our counterclaims. Over the course of this trial, 69 of those voters testified before this court. They came in one by one. They drove from large distances. Each one of them testified about how important their ballot was, why they took the time to come down here and appear before you to try and get their votes counted. Remember Frederick Amara? Mr. Amara's ballot was rejected because of his signature mismatch. He testified that he had one signature that he used when he was in a hurry and another when he had more time. Both of those were his genuine signature. He testified he was a citizen of Minnesota, more than 18 years old, met all the other requirements for lawfully casting an absentee ballot, but his ballot was improperly rejected. With his testimony in this courtroom, that ballot should be counted. He was a registered voter. So was his witness. Remember the Seeleys, Anthony and Rachel Seeley? They came into court with their newborn baby and passed the baby from hand to hand so that both of them could testify about both of their ballots. The Seeleys were both registered voters but were mistakenly given non-registered ballot envelopes. Their ballots were rejected because election officials couldn't find a voter registration application inside the envelopes. But the registration database confirms that both Anthony and Rachel Seeley were in fact registered voters. Both of them met all the requirements for lawfully casting an absentee ballot. Their ballots were wrongfully rejected and should be counted. There's the application and the envelope for Anthony Seeley. He was a registered voter. There's the application and envelope for Rachel Seeley. She was a registered voter. Remember Betty Narveson? She testified that she forgot to fill out the ballot envelope and was sent a replacement. There's her absentee ballot application. On the left is her first absentee ballot envelope. It was blank, but she was sent a replacement. She properly filled it out. That's the one on the right, but it was rejected because someone thought she wasn't registered. That's the notation at the bottom. But she was. Remember, she brought in her election registration confirmation card. She even pulled it out of her purse on the stand to show the court. We took a moment before she took the stand to copy that and staple it to the back of the exhibit, and it's contained in the exhibit in evidence before the court. That confirmed her registration. She properly complied with state law. She voted only once, and her vote should count. And there were others who, because of health issues, age, or infirmity, couldn't travel to this courtroom, even from nearby suburbs, but who testified in depositions. We went to them so that their votes could be counted. Like Jack Larson from Champlin, whose ballot was rejected on account of a signature mismatch decision. He's lived in the same house for 30 years, and votes like clockwork in every election because it's important to him to participate in our elections. He testified that the signatures on the envelope and on his absentee ballot application matched, and his testimony and the documents collected demonstrate that he was registered, his witnesses was registered, and he did everything necessary to properly cast his ballot. It was a mistake to reject it, and this court has the power to correct that error. Or Elizabeth Davies from Minneapolis. She testified by deposition. She's lived in the same house since 1973. She's fully registered to vote, and her ballot was rejected for lack of a voter registration application. Trouble is, she didn't need one. She and her witnesses were fully registered to vote. She did everything right. We've established all of the requirements with specific admissible evidence. It's contained in her deposition transcript, and her ballot ought to count. Every ballot tells a story, and every witness has a story, and we've heard a lot of them in this courtroom. Voters who work hard every day and did everything they could to lawfully cast a ballot in the election. Now, in addition to these individuals who appeared in the courtroom and testified, we presented testimony from auditors and election officials and collected the necessary documentation to prove our case. As the court will recall, we presented testimony from Duluth City Clerk Jeff Cox. We presented 35 ballots that were utterly proper in every respect. As Mr. Cox admitted on the witness stand, the only reason they'd been rejected was either because the voter or the witness hadn't provided a date when they signed it, or the dates didn't match. But neither is required by state law. And yet a Coleman attorney prevented those 35 ballots from being counted during the Supreme Court review process. None of them should have been rejected, and they should be counted now. I won't go through 35 of them, but I think it's important to take a look at one. This is an example, Guilford Lewis from Duluth. This is the voter registration application. Everything's right about this, as Mr. Cox confirmed. He signed it. There's his absentee ballot envelope. You can see the date mismatch, and you see the explanation, different dates provided in the box. Here they are side by side, so you can see the signatures match, the address matched, the witness signed it, the witness provided an address. Mr. Lewis was registered, so was his witness. We went through this 35 times one afternoon. I'm sure I probably put many of the reporters in the room to sleep going through this, but I'm sure the court understood the importance of what was going on. 35 ballots, 35 instances where a voter did everything right and the ballot hadn't been counted. Every one of them tells the same story. Every one of them should have been counted, but wasn't because of the same problem. Now, in the compilations we provided to the court earlier this week, we provided tabbed exhibits broken down by individual voters to assist the court in the task that lies before it. We've collected absentee ballot envelopes, absentee ballot applications, and voter registration confirmations for hundreds of voters who couldn't travel to this courtroom or appear by deposition. In addition, we have prepared and will be submitting later today a comprehensive spreadsheet summarizing the proof in the record with respect to our counterclaim on absentee ballots. And I'd like to point out just a few things about that spreadsheet, if I could. This is the format that the spreadsheet will appear in. I apologize for the small print. On the left-hand side, we have the name of the voter, and then in progressive boxes marching across the screen, the first column is testimony, and we've indicated the name of the witness providing testimony and the date of the testimony if there's testimony bearing on that particular absentee ballot. Next column over provides a specific identification of the exhibit and the date it was admitted for envelopes. The next column is application, the absentee ballot application. Again, we provided the specific exhibit number and the date it was admitted. Next column over is voter registration. Again, SVRS means unlike the other spreadsheet. This means there actually is an SVRS printout, and we've given the exact exhibit number where you can find it and the date it was admitted. Next column over is the witness voter registration lookup. Again, we provided the specific identification of the exhibit number and the date. Other evidence will largely be blank. If there's other evidence submitted relevant to the individual voter, then it'll be added there, but for the most part, that column isn't used much. And then we've gone through each of the elements required and identified where, using EX as an abbreviation. That means it's in the exhibit cited in one of the first columns. And in the exhibit will identify each of the elements required. And you can see as we go across, we've filled in almost everything. T, down 3 columns up from the bottom, you see that little indication means that point was established not only by the exhibit, but in addition by the testimony, in that case, Nicole Bowman's testimony. So left to right identifies all of the elements proven. All told, we have fully established every element required for at least 252 voters identified in our counterclaims. We've provided specific identification of every fact necessary for every one of those voters. We've demonstrated that the voter was registered or properly completed a voter registration application. We've demonstrated that they completed an absentee ballot application, that both the witness and the voter completed certification forms, that the signatures matched, that the address matched, and that the voter did not otherwise vote. All of the specific elements required by this court have been met with respect to these 252 voters, and they're identified in our spreadsheet and will be in our proposed findings of fact that we file either later today or next week, I believe, is when we're filing those. These are beyond dispute, along with the 47 ballots that the court has already granted summary judgment with respect to. Nearly 300 ballots should be opened and counted. There were 2.9 million ballots cast in this election, and approximately 280,000 of them were cast by absentee ballot. Of those, approximately 11,000 were rejected. 933 were ultimately counted after a careful secondary review by the counties and the candidates pursuant to an order of the Supreme Court. After 7 full weeks of trial, it should come as no surprise to anyone involved that ultimately only a few hundred ballots have been fully proven to have been lawfully cast but wrongfully rejected. That's less than 0.1% of all absentee ballots cast in this election. That number is a testament to the accuracy of this election. It's a testament to the hard work of Minnesotan election officials and to the integrity of this election. As I said in my opening statement 7 weeks ago, the vast majority of rejected absentee ballots were rejected because they should have been rejected. This court has now the opportunity and the duty to correct the relatively small number of errors and to confirm that Al Franken received the highest number of votes cast in this election. It's been a long road since November 4, 2008. First, Minnesota conducted the largest statewide recount in American history. Hundreds of local and state election officials devoted thousands of hours to conduct a painstaking ballot-by-ballot manual recount of 2.9 million ballots. At the conclusion of the recount, they forwarded their work to the State Canvassing Board, which formally certified the results of the recount with this certificate signed on January 5th, 2009, that certified that Al Franken received the highest number of votes for the office of United States Senator. Second, this court presided over what is undoubtedly the most comprehensive election contest in history. 134 witnesses testified, 38 county and city officials appeared, and over 2,182 exhibits in countless binders have been admitted into evidence and piled up like snowdrifts on the bookshelves, tables, and floors of this courtroom. With all that evidence now presented, it's clear that contestants have utterly failed to prove their case. This election, undoubtedly the most closely scrutinized election in Minnesota history, was carefully conducted, fairly administered, and accurately certified by the Minnesota Canvassing Board. This effort to overturn the results of the hand recount and the certified results of the recount canvass should be rejected. As the record before this court vividly demonstrates, Al Franken received the highest number of votes in this election. Al Franken is Minnesota's senator-elect. He is entitled to the certificate of election. Contestee respectfully submits that judgment should be entered rejecting the election contest in its entirety and entering judgment in Al Franken's favor on his counterclaims. Thank you.
Thank you, Mr. Hamilton. We will take a 15-minute recess and come back for further argument.